Weekly.
Item 20. Yesterday, Lordship kindly have a glance. Paperwork has not been accepted so far.
Yes.
Paperwork be accepted. Copy has been served only on yesterday. So let it be listed in the hearing list in the month of August. I know.
Why August?
The yesterday, your Lordship has already picked this 4-5 applicants over the year. This week and
No, I will put it in the weekly list. Hearing, whenever it comes, I will accommodate you. Don't. But
Item
weekly, 28 weekly list.
28.
it,
Maybe added to the weekly.
Weekly list.
Weekly list.
item 29, my lord. With consent of my lord, counsel for the appellant, let it come week commencing 19th of July, so that it can be hard and disposed of. Weekly supplementary asset, it can be
19th July.
much of
My lord, submission of a written note directed to within 7 days.
Where is that? Which matter?
CRLA doctors Suvanarayana Mahapatra.
That matter which your lordship has reserved the judgment, that rupees 20 was the bribe amount and appellant was the doctor. That's,
Okay.
I have already,
Give it to me today only.
yesterday, in fact, I have
lot
also,
of judgments are reserved, so I'm
Yes, my
getting
lords.
confused
Yes,
with
my
which judgment.
and in fact, yesterday I have also filed the written note of submission. Soft
Written
copy.
up note of
Yes.
submission which has come, you give it to me.
My lords. No, yesterday I filed in the registry. Soft copy and
I
hard
think
hard
from
copy.
the court hour only, I'll have to take little time
Yes,
for
my lords.
giving dictation.
Otherwise, it's not possible. A lot of judgments are now being
hearing
pending.
matters.
Yes, ma'am.
It takes time.
Yes, ma'am.
Yes. Start. You are item 1.
Item 1. 307 custody 26/11/23.
On 21st, your lordship directed me to obtain the instruction and injury everything, my lord, has come, my lord. But on the way, my lord, the
बारंबार
after
Tomorrow?
tomorrow, not 2 p.m., my lord. 2 p.m.
Pass out.
2 p.m.
Yes, completely.
2 p.m. right?
What is the offense?
307.
Oh,
That.
No, huddle the bomb.
Throwing bomb.
So far as the petitioner are concerned, they are not thrown the bomb.
bomb bala. Okay.
Yeah.
Chalo, anyway. Yes. Two, nobody there. Adjourn.
No, my lord. Item 2, my lord. This, the password. 1 to the
1 to the.
One to the
Yeah.
So for 3, my lord, state case, my lord.
Hmm.
I think while your lordship is at Supreme Court, my lord, your lordship perhaps appearing in this case, my lord.
Am I?
My lord.
Let's see.
For that reason, my lord, the matter will be,
Oh, Raja Acharya.
my lord.
I was his lawyer. I was his permanent lawyer.
If I am correct, by the time, my lord, all the
Before some other week. What is this matter is about?
cancels bill. Sorry, even case with the case.
I-
Mr. Amit was appearing for the opposing party, my lord. But in fact, he has not come.
1 minute. Where is that order? I'm not.
Page 8, my lord.
Page.
My lord, so far the petitioner, your lord's name is appears, my lord. Yes,
I have been doing
that day, my lord, Annex 1.
all these cases.
Matter 1 to Supreme Court, that had withdrawn. Subsequently, has been granted bail by the only court, my lord.
That there also I appeared. Yes.
my lord, I am on behalf of
Permission of the honorable. Yes.
I'm on behalf of Amit Bose.
Sorry.
I am on behalf of Amit Bose, my lord.
ठीक है, दे दे। अलग को भेजिए। इसको
Acknowledge me. Sorry.
Yes. This is appeal. Appeal against
4, my lord.
cancellation of bail granted
My
to
lord.
the party. When
My
the
lord, last exam, my lord, your civil case adjourned, my lord, on 26th, 20th June, my lord.
when the bail was granted?
My lord, bail granted, my lord, 11/5/2021. And they are sole ground, my lord. And they, since the case, during pendency of the bail application before the Honorable Court, he moved before the trial court granted bail. They are sole ground.
Without disclosure.
Mentioning
I
granted.
asked them to move the, show me the application.
But in fact, my lord,
Huh.
in page 5, my lord, Annex 2,
Huh.
6th line, my lord, from the top, my lord.
Yes.
Certified has been,
Appended.
my lord, appended on the bail application,
That
no other bail application pending. But in fact, 2021 case, my lord, that's it, certified. Subhash Chandra Acharya. Yeah.
Anyway, pass out.
Item 5.
Lordship, on behalf of Mr. Gauri Mondat,
Hmm?
may be permitted to withdraw.
Withdraw.
Yes,
Very
Lordship.
good. Withdraw. Give the memo.
Item 6.
Item 6, my lord, I am appearing for opposite party number 2 to 12. I want to file a objection, 1 week time may be allowed.
What is this matter is for?
Cancellation of a bail.
Yes, madam.
I am on behalf of Mr. S.B. Das, my lord. This is
When bail was granted?
bail was granted on my lord 16/9/2022 on this honorable court in ABLAPL number 11423 of 2022.
Yes. What are the grounds of cancellation?
My lord, ground is thereafter after going on bail, they are same thing they are doing. They are threatening. Again, we have filed 3 for FIR, that is annexer.
You after release on bail, they have been done.
Again, my lord. For that reason, this honorable court, my lord, directed State Council to obtain access on the subsequent cases, my lord, status of the, that has not been come, my lord. Your lordship can adjourn.
Next week? Next
1 week after
1
that,
week
I will
Next
take.
what? 1 week after. Yes.
Item 7.
Oblige.
Oblige.
Yes, sir.
I am, this is for modification of the condition led by the
What?
lower court.
Where is that condition?
Your lordship may kindly have a glance to the prayer portion. In this application, prayer portion.
Modify the bail condition number 1 and 2.
Your lordship may kindly there refer to condition number 1 and 2 of the trial, Lord and trial court.
Where is that, sir? Please.
About court adoption.
He shall not leave the jurisdiction of the court without prior permission of the court. He shall not tamper with prosecution witness in any manner.
Anyway.
Both these will be modified.
5 to 7 may be taken up first. Don't कहबे तो जहाँ allegation करिया कथा करियो.
5 to
7. 5 to 7 is the husband, 5 to 6 is the wife. They are implicated in a vigilance
5 to
case.
6.
5 to 7 are the
Item 8.
item.
Item 8. Okay. Item 8. Let us
Item
see.
8. ठीक है.
Yes.
Page 6 को जीवा.
6.
आगे.
Okay.
He shall not leave the jurisdiction.
नहीं, हजूर page 4 को जीवा. Page 4.
Page 4 of the petition.
Petition.
Now, what are the conditions? Show me the conditions.
Condition he has laid down the condition page 6 रे देखो.
6 रे.
He shall not leave the jurisdiction of this court without permission of the court. My lord, para
And
page 5 देखिए. Page 5 ता देखिए. High Court has granted that page 5 देखिए. Order dated 30/8/2012. That has been I have quoted that.
Yes, I am and that. Yes.
Yes.
Para 6, you have quoted everything.
Para 4 रा part ता देखिए page 5.
Para 4 part, yes.
Page 5.
This is an application for modification of bail condition number 1 as imposed by the order dated in vigilance case number 8.
Yes.
Now the pending in the court of considering the submission condition number 1 directing the petitioner shall not leave the jurisdiction of this court without permission is deleted.
1 is deleted.
1 is deleted.
2. Let us come to 2.
Letter that is the end page 6 में.
Yes.
He shall appear before the court in every date unless his personal attendance is dispensed with.
205 petition के लिए उसे allow करना. The court is so.
It says unless it is dispensed with.
Unless again both the petitioners are more than 60 years, and this petition is.
That's right, but the condition, what is wrong in the condition? If
That,
doesn't do, then challenge that order.
He is not allowing the petition 205.
Wait, show me one order, challenge that order.
My lord, সেটা নদেবা পরে
So I can't alter it to say that you allow the application.
খালি indicate করে দেবে if 205 petition may apply, that may be considered in its own perspective. এটি খালি mention করতে। I have a right to file the
Let him
205 petition.
by this petition, the petition is seeking modification of the order, modification of the bail condition, number 3, wherein the condition, the following condition is imposed. That is, he shall appear before the court in every date unless his personal attendance is dispensed with. Inverted comma. Let counsel for the petitioner submits that despite the said condition, whenever he moves an application under section 205 CRPC, the applications are not being entertained. He wants to withdraw the present petition, with the liberty to move application under section 205 CRPC as and when it is advised to, as and when it is required. If such application is moved, same shall be considered on its own merit.
I would have condition number 1 টা modify করে দেয় in view of the condition number
The already there, why should I?
না সেটা এটা 30/8/2012 হাইকোর্ট দিয়েছে।
And insofar as condition number 1 regarding not leaving the jurisdiction of the court, not leaving the petitioner from the jurisdiction of the court without permission of the court is concerned, the same has already been modified by the order dated 30/8 of 2012. Hence, no order is called.
The High Court, my lord, that may be
Passed by the High Court, hence no order is called for. Yes, both the matters are disposed. Yes,
my lord, the wife's petition 5 to 6.
yes.
সেটা সে হাইকোর্ট গ্রান্ট করলে 2019 বেল, he has laid conditions at page 5 maybe, the same conditions he has laid.
Yes.
I
but-
want that এই যেটা কোর্ট গ্রান্ট করছেন ডিলিট করে দিয়েছেন, that should be deleted.
It's already deleted.
No, that is in case of the husband, wife ro case.
Condition number 1, directing the petitioner shall not leave the jurisdiction of the court without permission. Right on. In this petition, petitioner is seeking modification of the condition number 1, whereby petitioner is directed not to leave the jurisdiction of the court without permission. He seeks modification of the same. In view of the amendments made in the petition, the condition number 1, condition number 1.
Small I.
Condition number 1, whereby the petitioner was directed to seek leave of the court while leaving the jurisdiction of the court stands deleted.
That is two, my lord. I'm sorry, my lord. Condition number 2.
Yes, 2.
She shall not leave the
Police shall
jurisdiction.
As and when required his or presence, the court initiates.
However, it is made clear that as and
205
when the petitioner is required by the trial court, he shall appear before the court
205
without.
that
It will be considered according to law, 205.
certainly.
Because 317 petition is there.
No,
317.
that's not required. If
370.
applications are moved, the same shall be considered on its own merit.
I'm not making any allegation. I had gone there and appeared in that case. The old advocate here, we filed both.
Now all the judges are transferred, don't worry.
No, it is not. These are the attitude of the towards the.
It's all right, one individual might have reacted that way, but now judges are saying.
No, allegation.
Why not 317 provision is there?
Now there you can move
So
up.
317 can be moved.
One particular judge might have behaved in such a manner. He is getting
That is
hurt out by
My
that.
lord,
Now everybody changed. Don't go ahead now.
Can be represented through advocate, my lord, 317.
Yes.
again, that condition.
Don't waste further time, please.
Condition সেটা ঠিক আছে 205 টাইপ থেকে মেনশন করে দিই।
My presence may kindly be
Yes, yes.
noted.
Go, sir.
Both are disposed of, my lord, withdrawn.
Disposed.
No, not disposed of, my lord. How can it be withdrawn?
Oh, it's all right here.
Withdrawn,
I'll change it.
not withdrawn, disposed
Yes,
of, my lord.
Please, your lordship.
9.
9.
What
I'm
is this
appearing for
matter?
9.
ଆପଣ objection କଲୁ
This may please your lordship. I'm on VC, my lord.
Yes, yes.
My lord, item 9, my lord, as Mr. Mahapatra is no more and I have no instructions regarding the case.
You are also Mahapatra.
Mr. G.N. Mahapatra. my lord.
What is this matter is about?
It's a appeal. It's a appeal about
Confiscation of special court act. Mr. Das will be
17.
appearing in this matter.
17. Huh? 17A.
Yes, madam. Mr. 17 minutes. Mr.
2011 matter.
Mallows.
Next week?
my lord.
Mallows, kindly indicate the name of Mr. Srimanta Das, Senior Standing Counsel.
Srimanta Das, Senior Standing Counsel.
Grateful.
Huh? Weekly? 9 weekly? Yes.
Item 10. May I please, Your Lordship? Because item 10 noting is there for acceptance of paper book, Your Lordship.
Yes, madam.
These are unnecessary proceedings. Acceptance. 2013 acceptance. Okay. So we will get accepted copy of the. You got the copy?
Yes, madam. I need the copy.
Yes.
Hon'Ble.
Item 11.
Mallows are calling this matter, Mallows.
Hmm?
Chronologically, it will come at the list. Wait.
11.
Item 11.
Item 11, Lords, today is for orders. Item 11, Lords, this pertains to a state vigilance revision, Lords. And Lords, in this case, today is for orders in the matter of limitation. We have filed the requisites. Notice went to PWA opposite partner 1 and 2, Lords. Return undelivered. Let me take the fresh steps, Lords.
Notice was issued to
OP number 1 and 2.
opposite party number
1 and 2.
opposite parties. Opposite parties. However, the service is not affected.
A return undelivered.
To take first steps. Let him do so within a week. Leave the matter after 2 weeks.
Fresh steps with correct address.
Yes.
12.
On the correct address. Huh? Yes.
Lords, this is also for taking fresh steps, my lord. Item 12, my lords.
Same for the correct address. Well, these are the matters, 2010 matters.
Yeah, but next time, my lords, I'll come up, my lords, without going to
This
the
is
merit.
against acquittal.
Yes, discharged. The discharge application was allowed. Both the accused person were let off.
2010, somebody is discharged. Today we are in 2024.
My lords, only
Shall I dismiss in default?
no, had there been any parental order that could have been done. My lords, that's similar. Let the formalities go over. And the lordship fix a date, both matters can dispose. I am with your lordship, my lords, for 2009, 2010 matters. Correct, my lords. Now, when they are let off for more than one decade, my lord. So the entire exercise, my lords, is only to, discharge certain professional obligations.
Matter arising out of an order by which the opposite parties, opposite, how many opposite parties? Opposite party has been discharged for offense under section. Offense under section.
12(5).
Offense under section. What are the sections?
Okay. Well, lordship, pass it on. I've sent the files for taking standards. Well, lordship may pass parental orders with regard to
offenses under section. This is an application arising out of an order by which the application of the opposite party under section 227 CRPC was allowed and petitioner was
let off.
Discharged for the offenses under section 120 capital B /420 /468 /471 IPC read with section 13(2) and 13(1)D of PC Act. The state has challenged the order of discharge. Order of discharge discharge. This matter is pending since 2010. No steps have been taken to serve the opposite party as yet.
When steps test has been taken off, but it is inadequate. That's why fresh steps were required to be filed. Fresh steps could not be.
And appropriate steps are not taken to serve the opposite party. The petition also suffers delay. By way of last and final opportunity, 1 week time is granted to do needful, leave the matter. That day I will dismiss.
Yeah, let's say fix a date.
Next week, next week.
Yeah, let's say fix a date so that it can dispose.
It shouldn't come on your head, so therefore I am writing it.
Yes.
Thereafter I will dismiss it.
18.
13.
May I please, madam?
Yes,
In this
sir.
case, the notice has gone to the opposite party complainant, madam. Delay of 3 to 30 days. And delay it has come, madam. So case of check bounce, confirmed by the appellate court, madam. 35,000 was the check amount.
Expensive.
And opposite party
What
counsel
is
is
check amount?
35,000 only. The counsel is not appearing, madam.
Convicted.
Convicted, confirmed by the appellate court, madam.
Huh?
Confirmed by the appellate court. NI Act.
Confirmed by.
Yes, madam.
What do you want? 35.
His counsel is not appearing, madam, is absent, and repeated calls is
The
not appearing.
accused counsel. You are the.
Complaint, I am accused counsel, complaint counsel.
Okay, you have been convicted.
Yes, madam.
What to do? Deposit 35,000.
That's where I will deposit, madam, with court below. Now here, madam.
What is the sentence?
Sentence, madam, 6 months and 35,000.
No compensation.
Compensation of 35,000, SI for 6, RI for 6 months, madam.
What you do is, I will appeal the conviction, give you probation, deposit 35. Check amount you deposit.
That's right, madam.
Sentence, insofar as sentence is concerned, I will give you PO. Finish. You need not go to jail, pay the check amount. He is happy, you are happy.
Institution agent.
Then who will receive the amount from the court below? Let's direct.
This is none of your business. Lying there, whenever he'll alive, he will withdraw. Otherwise, let it go. You have to pay.
I will pay, but somehow other the.
Then it can't be pending for.
Exactly, madam. So.
Shall I put it on Monday? Who was the lawyer?
Some madam. SK Dwivedi.
SK Dwivedi, ask SK Dwivedi.
Let's say issue notice to the opposite party, then.
No, this exercise has been going on since 2011. Why should the
Madam, now the lawyer is not, his lawyer is not appearing, madam.
But I can't keep on inviting lawyers like this in this kind of matter. Just see 2011 now.
That's
the
true.
court is unnecessary body.
Exactly, yes, madam.
Unnecessary
Yes, keep it to Monday,
I'll
madam.
modify it. Sentence.
Keep it to Monday, madam.
Monday, okay. Monday.
Yes, madam.
Let's may submit one thing, my lordship. Pass the order in item number 12, my lords. This is a case because this is a case of 2010. The earlier one, item number 11, my lord. This is also state case of 2009. Why not both the cases were taken up on 18/6? In both the matters, I have to take fresh steps, my lords.
That I in both the cases same order for there and at least on 18.
11 and 12 same orders. So 18 both are coming, my lords.
14.
Your Lordship, on behalf of N.K. Das, Your Lordship, we are unable to take the soft copy. Kindly direct the registry to.
I can't hear you.
Kindly direct the registry to serve a soft copy.
Copy. It is your petition. Your petition, you have to supply the copy to the registry, or you want
They have not served the copy on the State Council.
She doesn't have it. That's the problem.
Perhaps
She wants. Then counsel for the petition submits that she has misplaced her brief. Therefore, she wants to reconstruct the same. Petitioner is permitted to take copies from the registry in a pen drive. pen drive.
Okay. Okay.
During the course of the day, get the pen drive and take it.
And also serve the copy on the state council.
And after obtaining, after reconstructing the file, the petitioner is also directed to supply a copy of the petition to the opposite counsel. Yes.
Bless you.
Item 50.
In this case, Your Lordship, I have filed an interim application 122 of 2022, Your Lordship.
My lords, may kindly see flag C, my lords.
In this case, Your Lordship, the appellant died during pendency of the appeal, Your Lordship. And the conviction was under 13(2) read with 13(1)(d) to undergo 2 years RI and to pay a fine of rupees 1,000, Your Lordship. In default, to undergo RI for 2 months, Your Lordship. The Lordship may peruse the annexure 3 to the interim application, Your Lordship. That is the finding of the trial court, Your Lordship. Relevant order is under page 7 and 8, Your Lordship.
Yes.
May I permitted to place, Your
Yes.
Lordship? The record is put up today for consideration of death report submitted by Superintendent of Police Vigilance, Koraput Division, Jaipur, by letter number such and such. As per the record, one memo was filed before this court on 25/2/21 relating to death of accused Masood Khan, that is the present appellant, Your Lordship, in the year 2020. Direction was given to Superintendent of Police Vigilance, Koraput Division, Jaipur, to inquire the matter and submit death report of Masood Khan, if any, on the basis of letter issued by this court bearing number 158 dated 1/3/21. The SP Vigilance, Koraput Division, Jaipur, submitted the aforesaid letter in enclosing the inquiry report made in that regards by DSP Vigilance, Bhawanipatna Unit. The letter of SP Vigilance found annexed with a copy of letter given by
Yes,
the wife.
and everything is filed. Yes.
Yes, Your Lordship. Peruse the record. Only the deceased accused Masood Khan was facing trial in the present case under section such and such. As per the record, no other person has been arraigned except late Masood Khan. He was the sole accused, Your Lordship. Considering the aforesaid letter submitted by the SP Vigilance, Koraput, death certificate filed, it is found that the accused Masood Khan such and such died on 22/9/2020. Basing of the report submitted taking into account of relating to the death of accused Masood Khan, it is held that.
What is the problem?
It's because this was the order passed by the learned trial court, Your Lordship. But the appeal is pending before this court that was preferred in the year 2014, Your Lordship.
Application 394.
Yes, Your Lord. This is the interim application I filed, Your Lordship.
What is interim?
That IA, Your Lordship. By the
You want to continue the appeal?
no, Your Lordship.
No, my lords. That is the reason, my lords. May kindly see flag C. They have filed an interim application for abatement of the appeal, my lords. As the sole appellant is dead, my lords.
It will be abated.
Yes, my lords. I don't have any objection.
What is the problem?
No problem at all, my lords. Let it be abated.
Right. When it comes the sole appellant in the
Yes,
present
ma'am.
case stated to have been expired on 22/9/2020, and this factum has also been verified by the court below and passed an order dated 15/7/2021. In view of the fact that the sole appellant in the present case has already expired, the appeal stands abated.
Grateful.
Obey, Your Lordship.
60.
Please, Your Lordship. I am Messi, my lord. The petitioner has filed this application by challenging the order dated 22/2022 passed by the London Special Judge Vigilance, Bhubaneswar, in connection with towards release of the fixed deposits and other deposits, bonds, etc. Seized by the vigilance policeman. The actual background of the case is that, my lord, the husband of the petitioner, one Pradyumna Kumar Parida, who was the ex-general manager DIC Noyagarh, and he was implicated in connection with the vigilance PS case number 59 of 2016, corresponding to vigilance GR 113 of 2016. Under section 13(1), 13(2), and 7 of the PC Act, whereas this petitioner is the wife of that accused, as she has no nexus with that case. She is a government central government employee, my lord, serving as a PRT in Kendriya Vidyalaya since 1994, and out of her own income, she saved some fixed deposits, the TDR deposits, and other bank passbooks, etc., which has been seized by the state vigilance policeman. These properties are accumulated out of her own source and own salary after deduction of tax, as because she is a central government employee. The state vigilance police has no authority.
You are not an accused under 309.
No, my lord. No, my lord.
109, sorry, 109.
No, my lord. I am not an accused.
If Lordship permits, my lords, item number 16 and item number 7, both the cases, my lords, both the revisions are directed against an orders rejecting 457 application. One pertain to, in this case, release of the seized bank accounts, and item 17 also.
No, she is independently employed as a
Yeah,
central
that is a submission, but both the matters coming for the fast act. Lords, let me take instruction with regard to their complicity, my lords. And secondly, my lord, what is the stage in the absence of any interim orders? What is the stage, my lord? If the things are proceeded further, my lords, both cases can be mentioned. But I will come back to your lordship with the specific instruction under what circumstances the petitioner.
Yet been issued.
No, for the fast act is correct.
This is which item?
16, 17, both the items pertain to 457.
Issue notice to the opposite party. Item 16 and 17, both. And
17 is not my matter, man.
Mr. Das, Learned Counsel for the State Vigilance, submits that he would file a status report regarding the
both the cases.
In the present case, accordingly release the matter after 2 weeks.
2 weeks, and also the other matter instruction pertaining to his grievances, well, not that whether what is the nexus between the petitioner.
Anyway,
I'll come back. Both instruction.
Yes.
You'll also put it to a particular date, minutes.
Charge sheet has been filed or not?
Everything is.
Maybe I'll take back. You'll also fix a particular date, minutes.
2 weeks.
My humble submission in this case, my lord, the law and court below has partly allowed the prayer of the petitioner. And
let's see. Examine it.
Yes, ma'am.
Examine it. Let him give the status.
The particular date, ma'am, fixed here.
15 July? 15th July.
Obliged.
Item 18.
No. 18 copy not served. Nobody is appearing, my lord. Rabindra Kumar Patnaik. Mr. Rabindra Kumar Patnaik.
2013. None appears for the petitioner. 14. For admission. Oh, this is regarding what? This is not related. 4/9/2013. 4/9/2013. The petition is preferred. The petitioner has prepared the present revision petition against the order dated 4/9/2013, whereby the court of whereby the special judge vigilance Kalandi refused to discharge the present petitioner from the charges under section charges under section 13(2), read with 13(1), C and D, Prevention of Corruption Act, and read with section 409/420/468, 471, 477 bracket A, and 120B IPC. The matter is pending since 2013. In the previous occasion, when the matter was taken up on 25/2/2014 and 25/2/2014, None appeared for the petitioner. Today when
Is
the
the
matter
case?
is called up, none appears for the petitioner. Since the charge has already been framed way back in 2013, trial might have been proceeded.
Needless to say that after the framing of charge, the trial begins.
Trial might have been
Commences.
proceeded. Therefore, nothing survives in the matter accordingly dismissed. Yes.
Lordship, I record my appearance in lieu of my learned friends.
Yes.
Sangram Das.
That is my lord, vigilance case.
Vigilance case. Record it. Yes.
19. What happened in this case, my lord? Though the case admitted, my lord, but the LCR has not come, my lord. Noting is there. LCR may be called for.
Is against conviction.
Against conviction.
Call for LCR. And this. Yes. Weekly. Yes.
20.
This pertains to Malords and orders by which the discharge application are rejected. If a Lordship can peruse that page 15, Malords, that indicates that for framing
Discharge application rejected.
rejected. And Lordship turn kindly page 15 may kindly be glanced through, Lords. That indicates that on 22nd September to 15 was fixed for framing of charges.
This is in this petition, petitioner has challenged the order dated 24/8/2015.
24/8/2015, Lords.
By allowing 24/8/2015, whereby his application under section 227 CRPC for discharging him from the alleged offences have been turned down. Perusal of the order dated 24/8/2015 indicates that before the trial court, the
22nd September 2015.
22nd, perusal of the impugn order. Perusal of the impugn order indicates that the matter was listed for 22/9/2015 for framing of charges. Needless to say that since the charges was framed
In the absence of any interim orders.
in the year 2005, in the absence of any interim order, and the trial might have been proceeded. Therefore, proceeded. The next further, the petitioner in the present case remain absent when the matter was called for hearing on 25/2/2022, and even today none appears for the petitioner. Hence, the matter is dismissed. Yes.
21.
21 year lordship, pardon also appearing to VC.
In this case also, the London counsel for the petitioner, Dr. Linkamilot, he telephoned me and that some predicament is that bereavement in the family, somebody died.
The counsel for the petition submits that there is a bereavement in the family, hence he seeks an adjournment. Accordingly, the matter is adjourned.
केबे आसिबो कोन तो है
केबे दरकार
2 weeks after your lordship. 2 weeks after your lordship.
You are also
Hon'Ble.
22 Milots, an amendment has to be filed, Milots. May I be permitted to?
What amendment?
Milots, I had filed a discharge application which was rejected. Meanwhile, charge has been framed, Milots. I'll amend the petition to challenge.
What amendment? You file a fresh petition.
Yes.
Again, I'll have to file a
No.
fresh petition.
Yes.
You have to file fresh petition because
These are infractions.
2023.
It becomes infractious, I agree. But an amendment is also.
Petitioner submits that he in the present petition he has challenged the order by which his application seeking discharge has been rejected. Meanwhile, charges have been framed. Therefore, he seeks to withdraw the present petition to file challenge the order of charge.
Milots may mention I sought to amend the petition. Milots may reject.
Better file a fresh one.
To file a fresh petition challenging the order of framing of charges. With this liberty, the petition is disposed.
Yes, liberty is granted.
Liberty.
Agree. I'm grateful.
23.
Yes, sir.
In this case, your lordship is directed to assist your lordship.
Yes.
I have gone through the entire brief, my lord.
Hmm.
And from the evidence of the informant victim,
What is the offense?
376,
Hmm.
convicted for 7 years and 12,000 cost has been imposed, and thereafter it has been reduced to 2,000 by the appellate court.
Yes. Cost. Insofar as fine is.
Fine.
And but sentence of 7
Sentence
years.
of 7 years are there. Out of that, 5 years, more than 5 years he is in custody, and thereafter this Hon'Ble court has released on bail. He was arrested on 9/3/2006, and from the record I found it, and he was released on by this Hon'Ble court on 22/3/2011. Bail order has been granted. Near 5 years.
5 years already.
Already, at that point of time, he was released thereafter.
5 years already undergone.
And it is a case of consent also. From the evidence, if your lordship read one paragraph.
What is the age of the?
That is 15. No. As per the record, 91. Occurrence took place in 2006. It is 15 years. They are saying 14 years.
Below the consent, my lord.
Below the consent, yeah. That is. But circumstances says that, and the statement says it is consent one. Only period on
Custody.
Custody 9/3/2006.
3/2006. Okay.
That is date of arrest. It has been written in the
arrest.
On bail granted by this Hon'Ble court on 22/3/2011.
3/2011.
Other records are not with me also not in the record also. When he has released thereafter.
You show me a very relevant part of the judgment, appellate court judgment, and one paragraph at least. Give me the copy. One paragraph just.
Appellate court
judgment. You are so confident. See, judgment reserve. He has already reserved.
Only I pray if your lordship.
Because of Mr. Bishwa's presence.
No. Your lordship has told me that for that reason I have taken it yesterday and.
Under it is the case, my lord. The case, my lord. The evidence of let
Mr. Bishwa.
Only your lordship may see the PW's evidence first. PW 6.
Yes.
Got it?
How the trial court has dealt with, let us see.
Well, first, I am drawing your lordship attention because
PW 6.
PW 6.
This is the procedure.
Trial court has justified all these things because he is a minor and he is not a.
What are the evidences for minor? He is minor. How the trial court has arrived?
Because he is 14 years age, and the doctor has said that he is above 14 years within 15 years.
Oh,
then. And school registers are not the school where the petitioner has read, where the victim has read. That is another thing. My lord, your lordship may see. Did 6, my lord. I am informant in this case. Got it?
Yes.
The next page, my lord. Paragraph 3. That the vital part.
Yes, read it.
As I came to know that the accused is married with 2 children, I did not mix with him. Because allegation is since last 6 months, the accused is running before her and they have relationship.
He is PW 6.
6. I did not mix with him. On 1/3/2006, the accused came to our house. I confronted the accused about the fact of his marriage and asked him not to meet with me. But the accused told that although he is married, he will marry me for the second time. Then he forcibly raped me and threatened that if I disclose this sad fact, he will kill me and my parents. Hence, I did not disclose this sad fact to anybody. Then I stopped going to tuition for some days and remained in the house, depressed mood. And thereafter, I am drawing your lordship's attention to the cross-examination.
Yes. Para 5.
Para 5. Last portion because I tuition kathata seti achi. I used to go tuition at about 5 p.m. although I was not going to school during that period. But earlier I used to go to tuition after returning from school. I had stopped going to school about 1 year prior to the incident, although I used to go to tuition daily. Next paragraph 8.
Hmm.
Because it is a busy area, there are shops on both sides of our house. Although there are residential house near this said shops, I cannot say the number of said house. I do not remember the first date on which the accused has gone to our house. He used to come to our house at about 10 a.m. to 1 p.m. There is no door in our house.
Hmm.
And we have a shutter which remains half closed during daytime. The accused used to stay for 2-3 hours in our house, and for this said entire period, he used to manhandle me.
I have to wear needy and
That,
spot.
that person I am not going, my lord. From this, it is construed that it is a consenting part. But due to the age, everywhere it is. Only I
Doctor
pray,
says 14.
14 to 15.
And some evidence has come. What to do?
I pray only, your lordship, period undergone, because 5 years are already in custody.
Period undergone. Period undergone. And show me 1-2 paragraph where I can read. See.
My lord. Paragraph 19.
19 trial court.
9 appellate court. Your
Appellate
lordship.
court.
They justified everything else.
19.
18 and 19, everything has been mentioned. That is relating to investigation. There is one defective investigation because the date of birth seized from another school. Though the victim has stated she has read in such and such school, but the date of birth has been seized from another school.
But how will you discard the evidence of doctor?
No, I cannot discard the evidence of doctor because the doctor has stated that it is above 14 years, below 15 years. And there is an evidence of recent sexual intercourse. For that reason, I am saying that period undergone 5 years, because he has already stayed more than 5 years. Custody. I have gone through the entire file, but I could not find anything except this concerning parts.
इसमें custody कर दो 5 years ना?
5 years.
5 years.
9/3/2006.
Yes.
Released by this Honorable Court of 22/3/2011. Probably my brother will agree with this because
is record the period already undergone, 5 years period already undergone. And Mr. Bishwal, I will only as a token of the appreciation of your efforts, I will direct payment of 5,000 rupees.
No, I will not take a single pie. Your lordship, I direct, but he denied to take it.
Yes.
That may be
right on. The court offers to make an order for 5,000. He declined.
Well,
this is the great gesture.
Right. Delivery judgment, my lord. Kindly, my lord, appeal court judgment, my lord. Paragraph 9 and 10 are relevant, my lord. That been taken.
Para 9 and 10.
Okay. Everything is there.
They have stated relating to the position of law. I am not denying that is the position of law.
Paragraph 9 and 10. Relevant.
Page, my lord. Internal page 1, 2, 3, 4, 5, 6, 7. 8. It starts from 8, page 8. 11, 12.
Para 9.
Para 9 and para 10.
9
and 10.
10.
Appellate court सब एंगल टच करछन से मु आउ
पर 9 10 कर रही थी पर ये लिख दो
फाइन टा 2000 आइती ताको 1000
फाइन भी
1000 कर दे दे परियो कि नहीं के जान
कोड क्यों कौन matter heard at length. Mr. Arjun Kumar Vishwal, who was appointed as amicus curiae by this court on 21/6/2024, has extensively argued the matter. This court record appreciation for the assistance rendered by Mr. Vishwal although the court was inclined to direct direct payment of rupees 10,000 to Mr. Vishwal for the effective assistance he has rendered in this matter, but Mr. Vishwal, by way of gesture, has submitted that he doesn't want to accept the same amount. This court record appreciation for the gesture shown by Mr. Vishwal. Judgment heard, judgment is. Thank you very much. Okay. And keep some matters for today also.
24.
ଏଥିରେ କରି ହଉନି ବୋଲି ଖାଲି ପ୍ରିଣ୍ଟ କରିକି ଆଣିଲି ବେ
A lawyer of your stature should render assistance.
ନାଇଁ
so that we can-
once your lordship remember if you will access as per the Supreme Court when your lordship knows everyone can access the record but here we are unable to
No,
access it.
I am permitting you to access. This is for rendering assistance. Is not.
No, not if your lordship will, in the meeting it will be decided, then we can access the records.
You must access it.
Because
It's not for your personal use to assist the court.
no my lord जो record गुडा ଆମେ ପାଉନୁ କଣ ହଉଛି କି but ଆମେ ଯଦି access କରିପାରନ୍ତୁ download କରିପାରନ୍ତୁ then ସବୁ case ରେ ସୁବିଧା ହନ୍ତା କରିବା ପାଇଁ paperless ହବା
The
ଦରକାର
record which has come.
ହଁ except the order sheet. No.
What he says is something else. He says that instead of
For everybody.
pen drive business and all, directly access with
except the order
Online
sheet.
access. Online access.
Online accept
Because
except
you
the order
can't
sheet.
manipulate the
Yes,
record.
exactly.
Record is there. It is the public
Except the order
So
sheet.
now, my lords, all records are encrypted, my lords.
Yes.
The
Encrypted.
question of
So-
tampering does not
Tampering
appear.
doesn't
So sitting in your office, you should
Yes, ma'am.
open and read it.
And we can use
As this paperwork business will
yes
be stopped.
yes my lord.
Yes.
This is good
For
idea.
that reason I have also approached Justice Panigre on one occasion also. I am approaching your lordship also.
No, I'll speak to
Yes.
Panigre also, and I'll speak to Chief Justice.
Your lordship knows in
This is
Supreme
good.
Court also everyone can
Yes.
access the
We
records.
can access.
It will be better, my lord.
Yes.
Earlier there was a problem, but now it's
Since we are
very-
going for
Yes.
paperless from 1st July, it is necessary also.
Otherwise, it is half-heartedly doing it.
No.
Makes no sense.
You are referring one page. Your lordship will referring another page.
And then you take out the printout, take
Yes.
it in the pen drive, and all this business will be stopped.
Making
Once it is
paper,
Yes.
paper
If-
business is also very cumbersome.
if some
not required at all.
sir, if some cost should have been given by us also, it can be accepted by us also for assessing the documents.
Not
This is
that.
no cost is to be incurred by the court also.
My lords.
It is only you have to give access to the advocate who is on record.
Yes,
On record,
ma'am.
yes, my lords. Not for all.
Not for all.
Only whose name appears in the cause list, my
Cause
lords.
list. ଆଉ ତ କେହି ଦେଇପାରିବେନି ନା।
No.
And who is interested to read the record of all this?
ନାଇଁ, if your lordship accept the order sheet, then it's okay also.
Yeah.
Accept the order sheet, we can access everything. Because
Or
order,
otherwise, the formal order can be passed.
yes,
Give access to so and so.
So-and-so.
That also can
Yes.
be done on the request.
Yes.
So wherever there is an order,
it will
the
be
access is
beneficial.
That will be acted
When
upon.
your lordship is going for paperless, it will be beneficial of all.
and I'll tell you, this is going to happen. Eventually, this is going to
Yes,
happen, but it takes little time.
But our networking is not supporting them.
We are supposed to be the best in India.
Yeah.
Let's see.
In fact, we extend all solidarity to what Mr. Vishwal has put for the.
Right. That should be the spirit of coding. Otherwise, it'll never end. Thank you very much.
4 ବର୍ଷ ହେଲା ଗୋଟେ software ନିଜେ develop କରି ତା against ରେ ରଖୁଛି scan କରିକି।
And I will put it in the right
ୟୁଜ
space.
କରିପାରୁନୁ କାରଣ ଆପଣ ପାଖରେ ଯୋଉଟା ଅଛି ପେଜ ଆମ ପେଜ ମିଶିବନି। ବହୁତ ବେଳେ ବେଳେ କଣ ମୋହରେ ଯୋଉ କରୁଛନ୍ତି ପେଜ ମାର୍କିଂ ଭୁଲ କରି ଦଉଛନ୍ତି ନା।
Actually, the whatever development in this front is taking place.
That will be more beneficial, my lords.
We are trying to do that. Let us see.
Right.
Things are changing. Yes, madam.
Let's see,
24.
the last occasion, the court has directed to take instruction.
My lord, on 25th, 5th, 4th, and 24, my lord, you also directed the ISC
Status
partner
of the petition,
person to verify the status of the petition, my lord. That has not come, my lord. I am
Next week, Mr.
I will
Raghuda,
contact.
Mr. Raghuda, the counsel for the state submits that he has not yet received the instruction. Because of the election now, he might not have. Please the matter.
26.
May I please, Your Lordship? I prepare a short note.
Yes, now you give.
It is there.
This is short note, huh?
Yes. No, evidence is there. Xerox copy of the evidence.
Achha, then to it's all. But I say not exceeding 10 pages. You have exceeded by 2 pages. Anyway.
8, 9, 10.
11, 12 pages.
11 pages. 12 pages.
Anyway, no.
11, wrongly it was mentioned 12 pages.
Yeah, tell me.
9, 10 is.
Yes, madam.
9, 10 is missing, I hope. Okay, my lord, last occasion I had discussed some things, but everything should be clear from this written note. I had mentioned everything. First, that list of events I had mentioned in my notes, and directly, and the fact of the case, directly I want to draw my submission, page number 9. One by one, my submission. I hope one page is missing. It's all right. First, that basing on the sole testimony of the victim without any corroborative evidence, the land court below convict the petitioner. Number 1, my submission. And second, the court observed that I am inclined to hold. On this point, I want to draw page number 91, in internal page 17 of the judgment. Page number 91 of my brief. Last. My submission is that court observed that I am inclined to hold that the accused had entered into the house of the victim, used criminal force to her, and raped her against her will and consent. From the evidence of PW 14, it is noticed that the victim had not sustained any external injury. Therefore, offense 323 IPC is not made out. That is the observation of the court. From this, page number 19. That was mentioned in page number 19 of the judgment of the trial court. From this, it is clear that at this juncture, it was clear that when there is no victim, fact of the case might my lord already remember. Somebody poured poison in the tank of the accused. Accused moved to the victim's house to ask who had poured poison in my tank. So there should be tussle. There should be fighting between both the parties. There was, as per the victim, there is no consent. It was gone against her will. I want to say, if there is no
facts of the case, there should be resistance. If there is resistance,
there should be protest. There would be existence.
Where the finding is no case under 323 is made out. There is no injury.
There is no injury. That is no injury. No force is court observed at last. 14 page number 91 that it was proved from the evidence of PW 14, the medical officer clearly observed that there was no criminal force. So there is when there is no criminal force, might be there is no rape. If somebody is done this occurrence, done this fact with the against the will, against her will, then there should be criminal force and protest.
Yes.
This point 2. Next point, my lord, 3. That court below have failed to hold that there was civil dispute between the accused and petition against the victim. That was clear. Page number 38.
You are reading which submission?
3.
Okay.
3. Okay. That court below have failed to hold that there was civil dispute between the accused and brother-in-law of the victim, which is very much clear from the evidence of PW 12 and PW 16.
Right.
I had also written down the examination and cross examination, that is evidence of the PW, all the PWs, which is relevant for me. जोटी जति मत रिलेवेंट से गुडा को भी मध्य मु लिखि छ नोट रे 12 with the उर्मिला कबाट the victim. सी निजे कहिछि, सी stated, you'll see page number 17 of the page number 7 of my written note.
Yes.
Last para, it is fact that my brother-in-law Hariharan Naiko and the father of the accused are in litigating terms, and some cases including civil litigation is going on between them. And court also observed, page number 38, page number 38, page number 38. Page number 38 of judgment, trial court judgment. The learned counsel for the defense at the time of argument submitted that there is strong enmity between the accused and the victim, and has drawn my attention to the evidence of the victim PW12, wherein she deposed in the cross-examination that her brother-in-law Hariharan Naiko PW16 and the father of the accused are in litigating terms, and some cases including civil litigation is going on between them. Enmity is a double-edged weapon. In the case of enmity between the accused and the
Whether
victim.
the accused was medically examined?
Yes.
Any injury was found?
No injury is found. That was also in my submission. No injury was found. No external injury with the victim and with the accused. PW 13 and 14 is the doctor.
Who is the
persons?
Prosecutrix is?
PW?
12. Come to page PW 12.
Yes.
Read the evidence.
12 to evidence of the 12. Yes. From first?
Yes.
I know. Yes. I know the accused in the dock. I am the informant. On 22/3/2006 at about 12 noon at our home, the incident occurred. At that time, myself and my nephew and niece, that is PW 8 and 9, were sleeping. Meanwhile, the accused come to our home and asked me who has poured poison at his tank. When I denied my knowledge, he gave 2 kicks below to both my legs. One Hariharan Naiko came to our home with the accused. The accused asked him to leave our house. Thereafter, the accused given out my nephews and niece, driven out my nephew and niece. He then bolted the door from inside and came to me and forcibly removed my sari and committed rape on me and deposit my
despite my protest.
Despite my protest. बहुत दिन हेलान तो लिभी जाइछि बहुत अधिक. Despite my protest. At that time,
nephew and niece along with the father of
at that time, nephew and niece along with the father of the accused were shouting outside the door. The accused, after committing rape on me, came out having opened the door. When his father abused him, he threw him away, having told that he would keep me as his wife. The accused was dragging me to his house. When Jitendra Naik intervened and separated me from the accused. The accused then gave me 2 kick blows to both my buttocks. In the evening, a village meeting was convened.
The second assault. First assault is in the first she says forcibly removed my sari and yes. I deny knowledge. He gave 2 kicks, kick blow to both my legs. This first attack, huh?
Yes.
This is first physical assault. Then the second one is giving kick in the buttock. Second one. Next. Yes.
To paragraph number 2. I will read. Okay. The written report I have lodged is not available in the record. This is also a vital point. At first, after the next date of incident, the victim lodged one affair. Submit one written report.
Yes, come.
Yes.
Read it.
The written report I have lodged is not available in the record. it is not a fact that I have not stated before the IO and stated in the FIR, File Exhibit 3, that myself and my PW 8 and 9 were sleeping inside our home. And that the accused dealt 2 kick blow to both my legs, and that I protested the accused, and that my nephew and niece were shouting outside, and that the accused threw away his father, and that the accused was dragging me to his home to keep me as his wife, and that Jitendra Nayak intervened and separated me from the accused, and that the accused again dealt 2 kick blow to my both the buttock, and that the accused did not attend the meeting and threatened to kill others. Next,
Come to para 6.
para 6.
When the accused raped me. Read.
When the accused raped me, I was shouting.
Lordship, item 28, sir had to appear. I think learned counsel for vigilance has taken time. It has been adjourned to next week. Milord, may kindly fix the date as 3rd of July, Milord.
3rd of July.
Okay.
I am putting it in weekly.
Yes, sir.
Let me there in weekly. Whenever you are ready, you come.
Specifically, one case of mine has been adjourned to 1st of July. Other case.
I'll take it on 3rd indication for it. 3rd, I'll take it. Let it be there in the list. When you are ready, if you are, they are also overburdened because every day hearing comes, na. So
as far as this matter is concerned, Mr. Niranjan Mana will be conducting this case. This is 2015 appeals. So
you just tell him that on 3rd.
I will inform him matters because from 2015 to 2020 he will be dealing the appeals from 15 to 20, and from 90 to 14 it's my assignment.
Who is dealing with 91, 92? And
I am dealing, my lords. From 90 to 2014, it's my assignment, which my learned senior is mentioning right now. It is the appeal of the year 2015.
See, now from 27 onwards, there's 93, 94 and all.
Yes, my
You
lords.
just check what is the age, whether they are still surviving.
My lords.
It is more than 100 years.
Yes, my lords.
What is the use of doing it?
I've got item number 95. I was calculating the age would be around 80 years. If they are not responding, means whether they are illegal or not.
In fact, in item 95
Which
also,
item?
95 my lords in the weekly list.
95, you tell me who is the officer from whom we should get the information.
Actually, my lords,
Well-being can be ascertained.
95, 96 my lords, we are also not having the paperwork. So,
No, I'll give a direction to the concerned.
in fact, we are not having the appeal memo also, my lords. That is the difficulty.
Concerned superintendent of police vigilance.
Yes, my lords.
Okay, I'll give a direction to give the status report.
Matters that concerned vigilance official will be apparent from the appeal memo. Appeal memo. Yes.
You tell me which.
Yes, sir, can do that.
SP. You give the name 95 and
95, 97 and 128.
Ascertain the well-being of that.
Where well-being and whereabouts.
95, 96 and
95, 97, 128.
128. You give the name of the superintendent.
I'll give it.
Superintendent vigilance of so and so is directed to place on record the present status of the appellant and his recent address.
Matters. Copy of the order for communication.
Address. 3 copy दे दियो. Put a week per login.
My associate will give it.
Yes.
You give photocopy also.
Appeal memo photocopy.
Item number.
Put a week per login. You take the copy and send it.
Yes, my lords.
Yes.
Immediately I will send.
And also, by the way, direct the office with regards to item number 95, paperwork has not been prepared.
That we are not going away. Pen drive. Paperwork pen drive. We will take it.
LCR be 9.
You need not bother. Your juniors will do it.
No, LCR 9. 95 or 9.
95 nahi.
LCR has been returned after barcoding, my lords. It's there. Its soft copy must be.
Seniors should not bother. That's the office has to do it. They should be ready with the file. You have to read and come. And how they are arranging file, it is none of your business.
My lord, today's supplementary list item 30. There are 3 matters, and main accused has already been died. And there was a direction from this honorable court to file a written notes and submission on the legal points. What will happen in the death of the main accused? My lordship, neither they have prepared and let it be taken up on 26th as the lawyer for the appellant they had come. They are ready to do it on 26th. It will be finally heard. And in the meantime, we'll file the written notes.
Very good.
May I have some small submission, my lord?
Yes.
My lords, Mrs. Manoti's Mahapatra's endeavor is commendable. Mrs. Mahapatra. We are following your
She has
submission.
done really
Very passionate. Very fast.
Sam only from 2006-7.
And you are being recognized because of the efforts you are putting. You are not recognized as a person. You are recognized as a professional. That's very important.
Yes,
She's doing it with a lot of passion.
Passion range of the efforts he is making. That's very important.
He also so serious in
That's
I'm
very
serious in my case. So as for that, sometimes I have also argue with the justice. For case एते serious हो जाए तो केबे केबे court से तो भी मोर झगड़ा ही नहीं थी. In my past incident.
Thank you very much. You spared me. Then hearing will continue.
Only one matter left. Hearing only one matter left supplementary.
Supplementary which one?
27.
27. Yes. What is 27? Supplementary will exhaust 27.
27 come.
So 27.
Vigilance.
Noting has come that it should be taken about at 2 p.m. 2 p.m. Noting is there, man.
2 p.m.
So, my lords, I will be resuming after the lunch, man.
Yes, after lunch.
Great. It's great.
So I can utilize.
পঁচিশটা 25টা
petitioner custody matter 26/11/23. Charge sheet submitted by on 22/3/24. So far as the present petition is concerned, year-old cases are there. So far as the item 2 is concerned, 3 persons, they have no antecedent.
But insofar as in item 1,
There are 15 numbers.
15 cases.
Most of the cases he has been acquitted. Acquitted nahi jayechandi and are allegation case.
ठीक.
Niranjan Das, Ranjan Das.
And insofar as number 2, item number 2 is concerned,
No adverse. No
how,
adverse.
how many?
No case.
3. Bibhu Das, Ashok Das, and Anil Das.
Anil Das.
What are the allegations against?
So far, all these petitions, my lord, allegations are similar, my lord. And the main allegation against the 2 of the co-accused persons, my lord, Niranjan Das and Ranjan Das, they threw bombs towards the
Niranjan and
Ranjan, my lord.
Niranjan.
They are absconded, my lord. That is something showing them absconded.
They are the main accused.
Main accused.
They are the main accused.
My lord.
So then item 2 I will allow. Item 1 I will reject. 15 antecedent, 15 antecedent.
Condition, he will appear in the PS, my lord. Condition may be imposed.
Show me the list of cases pending.
ସବୁ 98 ମସିହାରେ 98 ଦିଟା 99 ଆଜ୍ଞା ଦିଟା 2000 ମସିହାର 4ଟା 2021 ର
ଏତେ କଣ ଏତେ କେସ୍ ତାଙ୍କ କେସ୍ ରେ
ଆଜ୍ଞା ସର 15ଟା କେସ୍ 2014 ପରେ ଆଜ୍ଞା ନଥିଲା ୟାକୁ ଏଇଥିରେ ଗୋଟେ ପକେଇଦେଲେ ଏଫଆଇଆର ବି ଆନା ରବି ଦାସ
2000
ରବି ଦାସ
2001 2015
ଆଜ୍ଞା
2018 2017
17 ଗୋଟେ 18 ଗୋଟେ ତାପରେ ଆଉ ନାହିଁ ଆଜ୍ଞା yes
thank you very much that you have served the nation very well. And see, you have been involved since 1998 onwards.
All cases, most of the cases he has been acquitted. Where he was peacefully living, my lord.
Number 2 related.
Number 2, my lord, the second bail application earlier lords that after some already some
the present petitioners had approached this court for grant of bail by filing BLAPL number 850 of 2024. This court, by order dated 14/3/2024, had rejected the bail plea. However, granted liberty to the petitioner to approach the, revive their bail plea after the charge sheet is filed. Also, the petitioners are in custody since 26/11/2023. The charge sheet in the present case has been already laid down by the police on 22/3/2024. 2024. When you approach the trial court?
Trial court approached 10/4, my rejected my application. 10/4/24. 10th of April 24.
14th March 2024. I asked you to go and move application after
Commission charge sheet. After submission of charge sheet, bail was rejected on 10/4/24.
No, where is that order by which I have
33. Case 33.
33. 33. 1 minute. Case 33.
Rejection of upper lower court. Rejection of lower court order.
No, where is that? No,
Page 33
the earlier order by which I asked you to approach after the charge sheet is filed.
This is the order.
लिखो ऊपर लिख दीजिए ना हाँ नहीं ऊपर नहीं approve to grant liberty to revive the bail plea, renew the bail plea after the charge sheet is filed. Charge sheet is filed in this case. Thereafter, when you move the application?
Thereafter, I moved the application before the court.
Where is that?
Submission of charge sheet, bail was refused, annexure 3.
Annexure
3, page 33.
33.
Yes.
33. Annexure 33. Where is the application?
Charge sheet before that.
Order date 10/4/2024. Again rejected. That's it.
10/4. That is filed on 22/3/2024. Thereafter, the petitioners moved application for grant of bail before the court below.
On 10/4/24.
By the impugn order dated 10/4/2024, the trial court rejected the bail plea of the petitioner by impugn order. Assailing the same, the petitioners have approached this court by way of the present petition. The allegation against the petitioner, petitioner are similar to that of the co-accused, those who have already been granted bail. Who are the two people, those who are absconding?
Niranjan and Ranjan. Niranjan Das and Ranjan Das.
Niranjan Das and Ranjan Das, those who are absconding, are the main accused in the present case. Those who have alleged to have pelted two numbers of bombs towards two numbers of bombs, resulting in which caused injury to how many people?
2 persons.
Injury to two, cause injury to two people. The by the order dated 14/3/2024, this court had granted bail to one Ajay Das. The case of the present petitioners are similar to that of the Ajay Das. Therefore, on parity, the petitioner is entitled to bail. Taking into consideration the tapre sheet format the petitioner submits that land council of the petitioner submits that there is no bail plea pending before any other court moved by the petitioner. She is normal paragraph. Taking into consideration the period of custody from 26/11/2023 and nature of acquisition, and the fact that the co-accused person has already been granted bail, I'm inclined to admit the petitioners on bail. And the petitioners in the present case be released on bail by the related court in session over the matter in the aforesaid case on such terms and conditions as it would deem fit and proper, subject to further condition that they shall participated in the trial and shall not tamper with the evidence in any manner whatsoever. For the violation of the bail condition shall entail for cancellation of the bail granted by this petition. Okay. Insofar as number 1 is concerned.
No, another item number 1.
Item number.
You will appear in case.
No, I'm not involved.
Your own case, my
In
lord. So, sir, that
the
so far as
petitioner, the learned counsel for the petitioner submits that the other co-accused persons have already been granted bail. So he is entitled for grant of bail in the present case on the ground of parity. Mr. Ragada, on instruction, have placed on record the antecedent.
Before submission of charge sheet, this application was moved. Liberty may be granted, moved once again before the trial court.
Learned counsel for the petitioner seeks to withdraw this petition to approach the court below at appropriate stage. With this liberty, the petition is dismissed. Yes.
Disposed of. Dismissal with death penalty.
How disposed of?
Since all the co-accused
15 cases.
15 most of the cases he has been acquitted.
Anyway, I am not inclined. Otherwise, I would have given. Oh, I granted bail to everyone. Now, why not?
7 रहेगा 8 मास रोई लेंगे.
Bomb.
Bomb से या ना रहेगी bomb
जाओ.
बस के ही है. FIR भी ना नहीं है.
ठीक है, I am entitled to my view.
Since co-accused person granted bail,
I have recorded that.
Indicate that.
I have recorded that. But I am not inclined to grant bail in view of his antecedent. He is involved in 15 cases. If you want me to write, I have to give reason. If I will write that co-accused person have been granted bail, why I am rejecting them? For rejection, I have to give a reason. So therefore, simply withdraw and go and bail. If you want me, then I have to write that he is involved in 15 cases. Otherwise, I can't reject it. Na? If I will say that I have granted bail to all other accused, why I am rejecting this?
Since co-accused person granted bail, I approach the trial court, parity shall be maintained.
Why I am not giving bail?
That may be indicated.
I will indicate everything. I will write down. Learned counsel for the petitioner submits that he is entitled for his client is entitled for grant of bail in view of the fact that all co-accused persons have already been granted bail, and his case on parity is entitled to co-bail. However, Mr. Ragada placed on record the instruction regarding the antecedent of the petitioner. Petitioner appears to have involved in as many as 15 cases. Therefore, I am not inclined to entertain the bail application at this stage. However, the petitioner is granted liberty to approach the court at appropriate stage, approach the court below at appropriate stage for the said relief. With this liberty, the petition is disposed of. Yes.
Okay.
Yes.
Item 4. Our concession bail, while pending the bail application before this court, my lord, again we move the court below and according to court below release him on bail, my lord. That has mentioned the order sheet.
The petitioner is challenging the order dated
11/5/21.
seeking cancellation of the bail granted to the opposite party number 2.
My lord.
Opposite party number 2 on the ground that while his bail application was pending before this court, the opposite party had approached the trial court for grant of bail. In the bail application, he has not give where is that
imputed page 5.
Page 5. In the
stated that no other bail
application, he had given a certificate that no bail application is pending before any other court. In view of the fact that the wrong declaration certificate is given by the opposite party number 2 before the court below and sought and obtained bail order, the petitioner is seeking cancellation of the same. Cancellation of the same. When the matter was taken up by the coordinate bench, the following order was coordinate bench on 1/10/2021. Following order was passed. Following order passed. Subsequently, the matter was taken up by this court. and request was made by the opposite party for adjournment. When today none appears for the petition. I'm not inclined to cancel the bail granted by the court below. However, the certificate and declaration given by opposite party number 2 before the court below is a serious issue, and it is basically misleading the court or withdrawing material information from the court. Therefore, I impose cost of rupees 15,000. Cost of rupees 15,000 on the petitioner for having concealed the fact that application, bail application was
not the petitioner, my lord.
sorry, opposite party number 2 for having concealed the fact that his bail application was pending before this court and he has given a wrong declaration before the court below. The cost shall be deposited before the, this is 207 or what?
This case.
Offense?
Offense, my lord.
302.
302 nahi. Charge sheet is 498, 304B, 306.
The cost will be deposited where?
Set kariye se
District Legal Services Authority.
It is assign set kariye.
This is Legal Services Authority, isn't it? This is cost shall be deposited to the Legal Services Authority. At cancellation of bail is he ultimately liberty is involved because he has given wrong declaration. Some cost has to be imposed. What to do?
Load direction nahi the load for the load court below the asking to deposit.
Oh, sorry. Court below?
Court below ask the accused to deposit the same. Otherwise, it will not deposit.
In the event
Trial court is to monitor the deposit.
After the opposite party number 2 is directed to deposit the cost before District Legal Services Authority and furnish a report of compliance before the trial court. In the event cost is not deposited, the bail granted by the court below shall be shall stand cancelled. चलो कुछ तो होगा. चलो. Yes. 27. Yes, we'll continue this now. Yes. Yes, sir.
That was heard by your lordship. FIR was on
We were there in the evidence of the PW1. PW1.
52 and 51B of the PC Act and 161 IPC. So before we go to the evidence, lordship, I ask your lordship to kindly.
Oh, ये paper उधर paper underline करती Yes. Yes.
Your lordship, see the charge once again at page 2.
Page 2.
20.
Oh, 22, right. Yes. 22.
The first charge, my lords. That you so and so while employed under the Director of Treasuries and Inspection Orissa in the capacity of a public servant as senior clerk, office of the Sub-Treasury Officer Burla, on 28/6/28 by corrupt and illegal means or by otherwise abusing your position as a public servant, obtained for yourself a pecuniary advantage of rupees 900 from complainant so and so to pass the pension and gratuity bill of his father. The charge is that the bribe was obtained for passing
the gratuity and pension.
The second charge, my lord, says that you so and so during the said time and place and in the said capacity accepted from complainant so and so rupees 900, which is a gratification other than legal remuneration as a motive or reward for doing an official act. That is to pass the pension and
The same.
gratuity bill of his.
Yes.
Now, your lordship will look at annex page 20, that is the. What is the allegation in the?
Yes.
Allegation in the FIR is.
पेंशन एंड ग्रेच्युटी हिसाब करिवारे मोर बापांकु ठारु 14,000 एथि टंका पाइबे
बाघ बाबू मते 1400 दबाकू पड़े. Now your lordship may mark from this sentence. ମୁଁ ବହୁତ ଅନୁରୋଧ କରିବାରୁ ସେ ବହୁ କଷ୍ଟରେ 900 ଟଙ୍କା ନେବାକୁ ରାଜି. ମୋ ପାଖରେ ସେତିକି ମଧ୍ୟ ଦବାକୁ ନାହିଁ ବୋଲି କହିବାରୁ ଟଙ୍କା ପାଇଲେ ଦେବା ପାଇଁ କହିଛନ୍ତି ଓ ପେନସନ କାଗଜ ମଧ୍ୟ ରଖିଛନ୍ତି. Now mark what is the
very very important. The ମୁଁ କହିଛନ୍ତି ମୋ ପାଖରେ ସେତିକି ମଧ୍ୟ ମୋ ପାଖରେ ସେତିକି ମଧ୍ୟ ନାହିଁ.
ଟଙ୍କା ପାଇଲେ ଦେବା ପାଇଁ କହିଛନ୍ତି.
ଟଙ୍କା ପାଇଲେ ଦେବା ପାଇଁ କହିଛନ୍ତି
ଓ ପେନସନ
କାଗଜ ମଧ୍ୟ ରଖିଛନ୍ତି.
ଦିଟା ଜିନିଷ ଅଛନ୍ତି.
Payment will be made after the
transaction.
After the
Transaction.
And second, the pension paper was with them.
Right.
That these are the two.
Yes. Now I will ask your lordship.
ମୁଁ ଆସନ୍ତା କାଲି that is not.
ବୁର୍ଲା ପାଇଲା ପରେ ବାଘ ବାବୁଙ୍କୁ ତାଙ୍କ ମାଗିବା ଅନୁଯାୟୀ 900 ଟଙ୍କା.
Then that was the condition.
Yes. FIR. Now I would ask your lordship to look at the provisions of the Act itself, section 5 of the PC Act, 1947. Net rating.
That must be the new act, madam. It's
Madam, net rating.
this is Act of 1947. Lordship, may kindly have. I have a copy of it.
Yes.
Lordship, kindly see section 5.
9.
5 minutes.
5. Okay.
1 reads like this: a public servant is said to commit the offense of criminal misconduct. A, if he habitually accepts.
5. You are reading 5.
Section 5.
Yes.
Clause 1.
Yes.
A public,
If he is habitually.
if he habitually accepts or obtains or agrees to accept or attempts to obtain from any person for himself or for any other person any gratification other than legal remuneration as a motive or reward such as is mentioned in 161. So the important words here are habitually accepts. That he must be habitually accepting some gratification which is not legal remuneration.
But expression is or.
Or
Either as a motive or as a reward. This reward part, my lords, is not there in the new PCI. ये जो FIR story टा होची, जे मु कला पर टंका पाइले देवा पे कहिसथि त मु टंका पाइले देबी एटा रिवार्ड टा
कले रिवार्ड देबी
किंतु 51A रे चार्ज ही कारण habitual acceptance नहीं charge is under 51D which says
51D. Yes.
if he by corrupt or illegal means or by otherwise abusing his position as public servant obtains for himself or for any other person any valuable thing or pecuniary
advantage. Yes.
This is the
charge
under which I have been charged. And as I place the charge before my lords, the charge does not relate to the allegations in the FIR. In the charge is that I received that bribe for the purpose of passing pension and gratuity bill of his father, which is not the informant's case. Why I drew your lordship's attention is that the judgment begins also like that. May I draw your lordship's attention to the paper book at page number 8, that is the trial court's plan.
Page 8, huh? Yes.
Page 8, where my lords may look at the first paragraph, 3 lines from the bottom, that sentence.
Yes.
The allegations available from police papers But I am stressing on the police papers. This is the first judgment that I have seen, wherein the judge, instead of referring to allegations arising out of evidence, says that the allegations available from the police papers are that the father of the complainant was serving as a sweeper in Burla Medical College, Burla.
He is referring to the charge sheet.
He is referring to police papers with the charge sheet. 6 years back, he got retired from government, suffered from continuous illness. The complainant got his pension papers prepared and finalized at Bhubaneswar in the office of the Accountant General and Director of Treasuries. This sentence is important. What is the charge and what is the finding? The charge is that I was...
This is not finding. This is only the narration of the prosecution story.
Narration of the prosecution story as per the police report.
As per the charge sheet.
Yes.
Yes.
The narration of the prosecution story should be as per the evidence that is accessed, not as per the charge sheet. The prosecution story, my lord, at the end of the trial is as per the materials adduced.
He intended to say that this is what is the
Allegations
police
are.
file the charge sheet and thereafter develops.
This is the story,
He
man.
doesn't intend to say so. Why? Because the charge is otherwise. The charge is that I accepted the bribe for passing the pension and gratuity, which is not the prosecution story as per the police paper. The complainant got his pension papers prepared and finalized at Bhubaneswar in the office of the Accountant General and Director of Treasuries. He brought copies of the pension papers to Sub-Treasury Burla to deal with the matter. He met the accused who agreed to finalize the account of his father, subject to payment of 10% of the amount, which roughly came to rupees 1400 only. Complainant expressed his inability to pay him such a huge amount and made further request to him, himself and through his friend PW2. The bargain came to be settled at rupees 900. Now, your lordship, to be paid after drawal of the pension amount.
That is what the story there.
That is the prosecution story as per the police papers, the charge sheet, which is not the evidence even of PW1, and it is not the charge also.
Let us see PW1 then, which I read. You read it extensively, right?
So, therefore, my lords, I placed this along with the charge that is framed and the provisions of the act.
Right.
Now, your lordship, we can go back again safely to PW1.
Yes.
Page 28 onwards.
PW1 is at page 2. He says, my father late so and so was serving as a sweeper in Burla Medical College Hospital about 6 years back. Having worked as such, he retired from service. After the retirement of my deceased father, I had been to Bhubaneswar on several occasions for getting his pension and gratuity. And for that purpose, I had been to the office of the Director of Treasuries and Inspection. After getting the pension papers prepared and passed in the office of the Director of Treasuries and Inspection, I came to Burla Sub-Treasury for working out this. Now, lords, if this is the evidence on record, that after getting the pension papers prepared and passed in the office of the Director of Treasuries and Inspection, I came to Burla Treasury for working out this year. The charge itself, my lords, is defective. That he came to, that he offered a bribe for passing of the pension and gratuity bills of his father. That has already been passed, my lords, at Bhubaneswar.
Only it is a matter of calculation.
Yes.
Exactly.
Now, my lords,
Yes,
what is it? I was introduced with the accused, namely Dayalal Bag, who was serving as a senior clerk during the relevant time. When I requested accused to pass the pension papers for the purpose of payment and of pension and gratuity, he told me that the matter cannot be finalized and that necessary calculation was required to be made for the purpose.
This is only for calculation.
Calculation.
His evidence is I asked him to pass the papers and he was told by me that calculation was required. Accused having calculated pension and gratuity gave me to understand that my deceased father was to be paid an amount of 14,585.
He has asked 14,000 because 10%.
10% of 14,585.
1400 because 10%.
10%. That was reduced to subsequently 900.
Accused demanded illegal gratification of 1,400 for getting the work done. I expressed my inability to pay the amount as I was earning my livelihood by pulling rickshaw. Relating to the illegal gratification.
Then your case is the FIR story beginning and the charge which has been framed and PW one when he come to the witness box, his versions are completely different. And charge, the very charge is framed differently, because the intention of the what you call the PW one is only to get the pension papers, pension paper. Here it comes to calculation, and the charge is something else. These are the variations, 3 variations.
But this calculation is the thrust.
But the calculation is only in witness box when he comes, he says.
Yes.
But when initial stage, he says that I only to get the pension paper. And in witness box, he says that pension papers were ready, everything is ready. I got it. But calculate, there is a problem in calculation.
No,
and why for he has paid money? Only to get the papers or for get it calculated and get the money?
Calculation.
That's the variation. Where the charge is something different.
Well, in that case, your lordship may kindly refer to.
So three different stories emanating from these. That's what his argument is.
Let my senior complete, then I will say.
This is sufficiently you have now gone through. Now,
Yes.
next point.
And the other aspect is that payment of the return of the pension book, it is there with him.
That I understood yesterday. I have underlined
The
two things.
second thing is sanction.
Come to sanction now.
Yes. Now your lordship.
A sanction clicks, then everything.
Yes. Your lordship may look at PW3.
PW3. Sanctioning officer?
He is the sanctioning authority.
Yeah.
On page 41.
Page
Yes,
41.
I'm there.
Page 41.
Yes, I'm there.
On 2389, I was one of the members of the arbitration tribunal Bhubaneswar. After having transferred from the aforesaid post, I joined as the Director of Treasuries and Inspection Orissa Bhubaneswar on 1589 till I retired. Now, my lords, so the sanctioning authority joins his post on 15/1989. The incident has taken place after the sanctioning authority, before the sanctioning authority has joined the post.
Right.
That is on 27/28. Now the second paragraph is very
89, 88.
Aye.
Okay.
Before I joined as Director of Treasuries and Inspection Odisha, a letter was addressed to the office, wide letter number 854/VL, dated 2/3/1989. Now this date is important. On 2/3/1989, when this letter was addressed by the vigilance to the Director of Treasuries for taking of sanction, PW3 was not there because he was then a member of the arbitration tribunal and he joined only on 1589. So before his joining, this letter is there asking for sanction.
2389, he was one of the members.
Yes.
On that day.
Yes, he was one of the members in the arbitration tribunal. So he was not Director of Treasuries then. And by the time he has joined as Director, this letter is there in his office. Says regarding sanction of prosecution against so-and-so working as senior clerk, Sub-Treasury Burla, along with a draft sanction order and consolidated report of investigation. So the sanction request.
But it was decided on 12/9/18.
Yes. The request for sanction
was the papers were placed on 12/9.
Before that,
yes.
Before that, your lordship may just bear. what were the contents of the letter? Two enclosures were there to the letter. One is a draft sanction letter and the other is consolidated report of investigation. So, FIR, other documents are
We're not there before it.
Then he says, my predecessor having been retired and I joined in his place, connected file was put up before me on 12/9/1989. Now this date again your lordship will know. 12th of September 1989. Then he says, I addressed a letter to the SP Vigilance Sambalpur to send the IO in this case to me for having discussion with me in connection with the case before according necessary sanction for prosecution. Your lordship may not turn the page, your lordship may just pay. So the records were put up with him before him on 12th of September 1918.
Right.
And thereafter he asks the SP Vigilance to send the IO for discussion.
Okay.
Then what he says, your lordship may see. The IO in this case on 2/8/89 met with me and discussed in connection with the matter. Yeah, how can the IO meet him on 2/8/89?
And
when
papers
the-
were placed on
Well,
12th
the records were placed before him. I also perused, and how can the IO discuss on 2/8? He says, I also perused the consolidated report of the investigation. Besides discussing with the IO, I was satisfied that a prima facie case existed against the accused. एठी भी डिस्कशन बेले कहूनी जे मु एफआईआर देखिली, चार्जशीट देखिली, सीजर देखिली कि जो खनल थालेन रिपोर्ट देखिली किछि आया कहू. So the entire sanction is passed with a discussion made before my lords the record was put up.
Let us see what is your cross to that effect.
No, I will put it important. Prior to that, I passed necessary orders on 25/10/89 according sanction. Prior to that, a letter was put before me by the office dated 2/3/89 pertaining to the matter. Exhibit 5 is the letter dated 2/3/89. 5/1 is the draft sanction order. 5/2 is the consolidated report. 6 is the order dated 2/8/89 indicating discussion by me with the IO and passing necessary order for according sanction. So exhibit 6 is dated 2/8/89 before the letter dated 2/3/89 exhibit 5 was put up before the sanctioning authority on 12/9/1989.
Okay. What have you crossed?
Yes, cross-examination. Prior to according sanction by exhibit 7, I did not call upon accused to meet with me, nor I had any discussion with any members of the staff in connection with the matter. After having perusal of the police papers, I was satisfied that a prima facie case existed against the accused, and so I issued the sanction order. On the request of the SP Vigilance to have a discussion with the IO, I called upon him for the purpose. Discussion by me with the IO was with reference to the papers which were there in the office file. It is not a fact that without application of mind, I have accorded sanction. So in cross-examination also he admits that the discussion was with reference to papers which were there in the office file.
But there is nothing put to him prior to this exhibit 7. How you have discussed 1/2/89.
No, that question was not put. It was not necessary to be put because his evidence in chief Millards is itself defective.
Anyway, this is a variation of dates.
Yes.
Here. On that count, you say sanction
No,
is not.
not only variation.
Non-placement of the relevant record before the court to arrive at a subjective satisfaction.
He has not had any discussion with the IO, would not have had any discussion because the date of discussion with the IO is before the records were put up before him, and his discussion is on the basis of exhibit 5/1. That is 5/2. which is the consolidated report of investigation. He, in cross-examination, he has confirmed, my lords, that except that consolidated.
The three
report-
things were there before him. Leaving apart this thing. One is the draft sanction letter, second is consolidated report, and third is the oral discussion with the police.
Yes.
These are the three things which were available to him.
And police papers.
Oral discussion.
Oral discussion, whether happened or not happened, it is doubtful because of the variation in the dates. This is what is the sanction is doubtful.
And a draft sanction order.
Subjective satisfaction of the sanctioning authority is doubtful.
This is
Because
my
nothing is
second-
placed before him,
Right.
basically, except a draft report.
Right.
On the draft report, he might have said, yes, go ahead.
And police papers were also there. He has perused the police papers. He has said that I have perused the police papers in the cross examination.
Perusal of police paper,
Yes, yes.
I was
satisfied.
This what he says, perusal of police papers. This cannot be relied upon or believed at all because he has had no discussion with the IO. And this is confirmed, my lords.
Let us see IO.
Yes.
Yes.
PW5.
Whether IO says
Right.
that.
Well, it's page 45 onwards.
Yes.
PW5 says. My lords, will look at page 47. Page 47, in the last part of his examination in chief, he has stated only three things, two lines. That sentence line begins with the word opinion.
Yes.
I placed all papers concerning this case before the Director of Treasuries and Inspection, discussed the case with him and obtained his sanction. केबे discussion कला कौन कला किछे हुआई.
But he says, I place all the papers.
Yes, but when? On 2/8, how could you have placed on 2/8? We at place करियो.
नहीं 2/8 से खाली डिस्कस करती.
केमिति डिस्कस करियो आई?
12 I understand. 12 there was no occasion for him to.
Exactly, Miller.
He should have discussed after 12/9.
Right.
12/9. And what is the cross?
Cross
Same alert which I was relying upon.
Cross I did not conduct a preliminary inquiry before entrapping accused, did not obtain a written explanation from the accused before prosecuting him. And so far as PW2, he has admitted that PW2 has not stated before him.
But
that
virtually there is no cross examination. Anyway.
My submission is whatever cross examination is there, my lords, that itself is sufficient. Why I am saying, as I told your lordship, my lords, the old code PC Act 1947 required punished habitual offenders. That is why, my lords, 161 was repealed when the PC Act 1987 was introduced.
But that is expression use or.
No.
Habitual is not in a continuation. It is or.
Yes.
If he can habitually
Habitually
accepts or obtains.
Or habitually agrees to accept or habitually attempts to obtain from any person.
But the charge is D.
Charge is D. Motive or reward, जोटा हला prosecution story FIR रे 51A cover करती as reward. मु काम कर देबी.
नले पैसा ना.
देला पर मु पैसा देबी. किंतु 51D टा तो reward cover करनी ना. There should have been a charge.
And there is a variation of as per the FIR and all, it should be 51A. Because he very categorically says that you get the work done, I don't have money, but I'll pay you once the work is done. Then you get the work done, I'll give you the reward.
Yes.
So that covers 5(1).
Section 13 रे charge frame 13(1)A, 13(1)E read with 13. See भले एक ही charge frame एक 51A, 51D read with section 5.
Yes. Yes.
So this is, my lords,
These are the two basic.
two basic infirmities, my lords, in the judgment. And my last contention before your lordship is that I will ask your lordship to kindly look at section 4, my lords.
Section 4.
Yes, section 4 of the PC Act 46.
Yes.
Section 4 of the PC Act is like section 20 of the EU.
Yeah, presumption.
Rebuttable presumption.
Rebuttable.
So I have already made a sufficient rebuttable presumption. The other aspect, my lords, will see is, just as in the current PC Act, my lords, that investigation is to be by somebody above the rank of a DSP, provided that there is a notification by the state government by general or special order. Same thing is there in section 5A. 5A says, subclause 1B says, elsewhere of a deputy superintendent of police shall investigate an offence punishable under 161, 165 or 165A of the penal code or section 5, provided the proviso is that if a police officer not below the rank of an inspector of police is authorized by the state government in this behalf by general or special order, he may also investigate any such offence. Now, this authorization also PW5 does not say. He does not say in his evidence that he is an inspector of vigilance. He doesn't say that in terms of the proviso contained in section 5A1, I have been authorized by the state government by notification to investigate into offences under section 5 and 161 of the IPC.
Okay.
These are the three grounds on which I say
Five A investigation, 5A investigation into cases under this act.
5 capital A.
Minus 5AD, elsewhere of a deputy superintendent of police.
No, it says who will authorize? Authorized by the state government.
State government has
It's
to.
not below the rank of inspector of police. Is authorized by the state.
Yes.
Authorized by the state government in its behalf by a general or special order. And he may also investigate the case so and so.
As we have a circular to that effect.
Show me the circular.
I will produce it, ma'am. I will produce that.
Because SP can't endorse in the FIR saying that I am authorizing XYZ to do it.
most official only, there may be a circular, but that has to be there in evidence. The PW5 should say that I am authorized by order of the government to investigate. That is not there.
That is not.
That is serious.
That they would have taken in cross also, my lords. No leading question has been given to that effect. Then, my lords, coming to the
Why
defect
will they invite something against them? Yes.
Now, my lords, coming to the charge part,
Yes.
which my learned senior has pointed out.
Yes, charge. Come to.
The lordship may kindly see section 215 of CRPC.
Okay. Yes, 250.
There's no error. Lordship got it, my lords?
Yes.
215. Effect of errors.
Yes.
No error in stating either the offense or the particulars required to be stated in the charge, and no omission to state the offense or those particulars shall be regarded at any stage of the case as material unless the accused was in fact misled by such error or omission and it has occasioned a failure of justice. let's here they have to establish how the failure of justice has occurred. And this has to be raised at the appropriate stage, not at this stage at least, with my respect to some position.
The appropriate, he is a convict and now he has been convicted, he can raise all this. They are legally.
Then when it's coming to the sanction part, once I'm relying on one judgment, your lordship may kindly see. This Paul Varghese versus State of Kerala and others, reported in 2007 SCC.
Yes, para?
Para 5, your lordship may kindly see.
Get the
Para 5. At this juncture, it would be appropriate to take note of what has been stated by this court in Central Bureau of Investigation versus V.K. Sagan and other. A court of appeal or revision is debarred from reversing a finding or even an order of conviction and sentence on account of any error or irregularity in the sanction for the prosecution, unless failure of justice had been occasioned on the account of such error or irregularity. For determining whether want of valid sanction had in fact occasioned failure of justice, the aforesaid subsection 2 enjoins on the court a duty to consider whether the accused had raised any objection on that score at the trial stage, which has not been done in the present case. Even if he had raised any such objection at the early stage, it is hardly sufficient to conclude that there was failure of justice.
Yes.
It has to be determined on the facts of each case, but an accused who did not raise it at the trial stage cannot possibly sustain such a plea made for the first time in the appellate court. Then when in Kalpanath Rai versus State, there he states, subsection 2 of section 465 of the code is not a carte blanche for rendering all trials vitiated on the ground of irregularity of sanction if objection thereto was raised at the first instance itself. The subsection only says that the court shall have regard to the fact that objection has been raised at the early stage in the proceedings. It is only one of the considerations to be weighed, but it does not mean that if objection was raised at the earlier stage, for that very reason, the irregularity in the sanction would spoil the prosecution and transmute the proceedings into a void trial. Thereafter, my lord, same thing has been reiterated in State by Police Inspector versus T. Venkatesh Murthy, 2004 Supreme Court. So therefore, my lord, this submission fails as far as sanction is concerned.
Yes.
Then your lordship may kindly come to the 313 statement, question number 1. Page 23.
23.
Yes, madam. The 313 statement. PW1, lordship got it, madam?
Yes.
PW1 Ramsay.
Question number
1, madam.
Yes.
PW1 Ramsay Banchor has stated that after retirement of his father, he obtained his pension papers from Bhubaneswar and went to your office for passing the same payment. You were then serving in Sub-Treasury Office Bulla as senior clerk. What have you to say? He was dealing with the pension papers and it was his duty to pass the papers, madam. This is what I want to point it out. Then your lordship,
what is your case? Whether the pension papers were there with you and it was a matter of calculation, or pension papers were already there with the informant and he gave it to you and you are supposed to calculate. What are the procedure?
My lords, may kindly come to the PW1 statement. Everything is there. PW1, my lords.
Yes.
Page 29. The sentence starts from the pre-page. I'm just reading it once again. When I requested the accused to pass the pension papers for the purpose of payment and of pension and gratuity, he told me that the matter cannot be finalized so soon and that necessary calculation was required to be made for the purpose. The accused, having calculated the pension and gratuity, gave me to understand that my deceased father was to be paid an amount of rupees 14,585 towards the same. The accused demanded illegal gratification of 1,400 for getting the work done.
So that's the problem. See, calculation is already done. Who is supposed to disburse the money? In any case, the accused can't, accused is not authorized to disburse the money.
No, my lord. His
Then
work,
obviously,
my lord,
what would be
his
the
work,
case?
his
The
work.
papers must be there with you.
My
Paper
lord.
must be there with the accused. Which paper?
My lord's papers are not, my submission is.
You simply tell me
My lord.
whether the gratification is for the purpose of calculation or it is for the purpose of giving the papers after.
For calculation, my lord.
Calculation is already done.
My lord,
14,585.
my lord,
What calculation?
this has been done after the assurance given by the accused and
Then
the
where
bribe
is the
money. will
occasion
be
of paying money? Already his job, work he has done, already he
My
calculated.
lords,
Why should anybody will give?
my lords, the chronology of events is that when he approached the complainant, the accused, he said he will do his duty only after taking the bribe money.
Yeah, but he's done it. He has calculated it.
My lords, he's done it with the assurance that he will be getting the bribe money after the payment is
Who
made.
is he a fool of first grade? After calculation is made, everything is done. He'll come and pay the money. Why should he pay the money? Calculation is done already. If the calculation is done, why should he come and pay? I can understand if he says that I will have to make the calculation and unless you pay the money, I will not calculate. I can understand that. But what is your case? For the purpose of calculating the money, you are supposed to pay 10%. And you yourself has given a very nice figure, 14,585. Calculation is done. Why should the full informant will come and pay you once the calculation is done? Answer.
Madam, the transaction has been made in that light only, madam. This is what the understanding was between the accused and the complainant.
That's what he is talking.
Lord Chief, kindly come to page 33 for a moment.
That is the catch.
But 33 for a moment, madam. Yes. Everything will transfer. This is the cross-examination part.
That is what I am struggling to understand your case.
Madam, this is the peculiarity of this case.
You are not sure about your own case. Whether for the purpose of giving the pension paper,
no,
he demanded the money, or for the purpose of calculation.
In my respect submission, madam,
your case is from the evidence it appears to be for the purpose of every paper was there with him. Yes. He collected the paper, gave it to him, say that your job is to only calculate.
Yes.
He calculated it to say that 14,585. Finished. Then why should he come and pay you?
Unless the calculation is being done, the process will
Is
not
it
be
your case
initiated.
that he is the disbursing authority?
No.
After calculation, he will disburse?
No.
Then why should he come to you to pay you?
Well, his calculation is to be done and forwarded to the Office of Sub-Treasury.
But that's not your case, sir. You are not said that I am withholding, I will not forward. Unless you pay the money, I will not forward. Does it say anywhere you show me? Single sentence.
A fair story is that I have withdrawn the money.
Well, I'll go to page 33 for a moment.
Very well. Yes. Try to understand.
Yes, I got your lordship's point.
If any sentence is there, I have calculated, although, but unless you pay the money, I will not forward this paper. Some sentence somewhere, if it's there, then you have a case. Show me that.
I'll come to page 33.
Yes, I am there in 33.
The pension book of my father, which I threw into the fire, was there in the Bulla Sub-Treasury, which was given to me.
Yes.
When I had been to Bhubaneswar to the Office of Director of Treasuries and Inspection for getting the pension papers and gratuity ready and passing the same, a copy thereof was given to me and another copy was sent to the Sub-Treasury Burla.
Stay here. The copy of pension paper and gratuity paper, one copy you got it.
And one copy was sent to the
Sent to him.
Yes, to
Why?
the accused office.
Why?
For calculation, my lord.
Calculation. Okay.
Yes.
Papers are there with you now. Proceed next.
I met the Sub-Treasury officer Bulla in connection with the payment of the pension and gratuity of my father. The copy.
Then you are sure that you don't need the papers. Papers are there with you. Now only thing is
not only with me, my lord.
Copy which has come to this gentleman.
Yes.
He was supposed to calculate the
basing
pension.
on those papers.
Basing on that paper.
Yes.
He has calculated.
Yes, my lord. He has calculated after having the assurance that if he processes and calculates, then after disbursement, he will be getting his bounty.
Where from you are getting it? From evidence.
Kindly read the next sentence.
Yes.
Now you are correct there, but where is that from evidence? That might have happened.
My lord.
I am sure that might have happened.
Yes, ma'am.
But we have to find it in the evidence.
I understand, ma'am.
Evidence is otherwise.
Then your lordship can see.
That is exactly what had happened.
Yes.
He calculated.
Yes.
He might have said that I have calculated, I am keeping the paper, get the money,
take the paper.
Take it. But that is unfortunately not coming in the record.
There are other things also I will point out.
Yes, yes, of course.
I met the Sub-Treasury Officer Bulla in connection with the payment of the pension and gratuity of my father. The copy of the paper which I received, therein the amount of pension and gratuity payable to my father was mentioned. Sir, please let me complete.
Yes.
I did not interrupt when you said.
No, it's all right.
It was also mentioned as to from which month my father was to receive the pension, but only the calculation of the money, total amount payable up to that date was left, since the same was not done in the office of Sub-Treasury Bulla.
Yes,
This calculation part. After I met the Sub-Treasury Officer Bulla, he directed the accused to make the calculation in respect of the pension and gratuity of my father. Accordingly, the accused made the necessary calculation and gave me to understand that my father was to get rupees 14,585. The calculation regarding pension gratuity was made by the accused inside the office. When the calculation was done by the accused and he told that the amount payable was as indicated above, the other clerks and the peons were present there in the office. After the accused made the calculation, he instructed me that unless my father comes, and thereafter, my lord, the withdrawal was made.
No, we read it.
My lord.
After the accused made the calculation,
after the accused
he
made
instructed
he instructed me that unless my father comes and puts his signature, the amount cannot be withdrawn. The accused further instructed me that my father should come, take the pension papers, and then he would get the money in cash by putting his signature and producing the paper in the bank.
Yes.
Then your lordship will kindly come to para 7.
Then he has not withheld anything.
No.
He has not withheld. His job was to calculate. He
Yes,
calculated.
his only
Your
duty
father
was
was supposed to go.
Yes. Then he went to the bank. Then they have withdrawn the amount. Thereafter, the bribe amount was paid. His duty was only to calculate and proceed.
Why he has paid? There was no occasion. Everything was done.
My lord, he acted too honestly. That means.
And your story is a honest informant and dishonest accused.
The lordship may kindly go to para 7, my lords.
Yes.
That loan, the factum of loan, my lords. Tapan Swai, who accompanied me from the very beginning of the episode, is my friend. It is not a fact, this is in the cross-examination. It is not a fact that the accused had asked.
Then don't read that. If you read that, then his story gets strength. Because you say that you are a very honest person. Maybe you are honest, therefore the loan which you have taken, you are returning.
This is the factum of.
Don't read that.
No, factum of loan.
That part will create.
The factum of loan does not corroborate with the evidence
and
of
you
DWI.
prove that the informant is really honest man. He went and paid after withdrawing. That's what his case is. He had taken loan, he's paying me back.
No, I want to state that this factum of loan is not been corroborated by the defense evidence. That I want to establish. I say it is not a fact.
I think we are struggling to get over what was the occasion for him to give bribe. If everything is done.
Again, I will reiterate that is for calculation.
He has calculated.
He has calculated, then processing has been done. And for this processing, he had demanded the bribe.
The informant who is, just imagine, the incident has taken place when? This is
88, my lords.
88. The informant is so smart to go to the police to give the complaint. Trap and everything he has done. He's not a fool that he would pay after everything is done.
My lord, sir, we should also remember that he is a rustic rickshaw puller, man.
And rickshaw puller, so smart rickshaw puller, after having done everything, after the officer done everything, he goes and withdraw the money and goes and pays him. Can it be believed?
My lord, kindly see the loan factor, my lord. That has not been corroborated by DWI. It is their own evidence.
I don't believe that loan story.
Yes, then
I'm not.
Then, my lord, I am out of the clutches.
His defense is loan. We can discard that part of it.
Yes.
Even if we discard that part of it, the prosecution has to come out. What is the motive behind paying? Because it is reward.
Yes.
Reward for what?
Calculation. And this is what the
he has
in
already
fact, my
done
lords, in the detection report, if your lordship may kindly see exhibit 4, the accused said that he himself has said that the Ramsay Banchur was pleased with his work and the amount given to him out of pleasure. This is what he has stated in the detection report exhibit 4. Thereafter, it's an afterthought that it was a loan.
Where are you reading?
Exhibit 4, my lords, the detection report, your lordship may kindly.
Exhibit 4.
At the spot, he says that being pleased by my work, I have been given this amount.
Where is that?
My lords, I am not having the detection report, but it's exhibit 4, my lords.
In the paperwork, it is not.
It must be there in the exhibit 4. Therefore, it has been
Detection
observed.
report, huh?
Yes, my lord. Detection report, exhibit 4.
The trial court deals with it.
Yes, it
Where is
it
that?
has been dead.
Show me.
Page 12, your lordship may see.
Page 12 of the
Judgment minutes. I'm not relying on the judgment.
Okay. 1 minute.
Page 12, last 3 lines.
1 minute. Yeah. Item 27, no? Yes, 27.
Lordship got it, my lord? Page 12 of the paper book.
Yes, 12, no?
Yes, my lord.
Okay,
This is the judgment.
1 minute. 12. T. 12. 5, 6.
Last 3 lines.
1 minute. 10. No, trial court judgment.
Yes, my lord. If your lordship may kindly see the paper book, page 12.
This paper book?
Yes, my lord.
Okay.
Page 12.
Yes.
The last 3 lines. The sentence beginning with rather. What you got it, my lord? There's a correction also, rather.
Yes.
Rather, he stated in the detection report exhibit 4 that accused Dayalal Bagh being asked the fact of accepting bribe of rupees.
Where is that?
Page 12.
12, yes.
The last 3 lines.
Last 3 lines.
Sentence beginning with the word rather. There's a correction also, my lords.
Yes, rather
he
stated
in the detection report exhibit 4 that accused Dayalal Bagh being asked the fact of accepting bribe of rupees 900 had stated that as Sri Ramshai Panchor was pleased with his work, this amount was given to him out of pleasure and he accepted it.
That is what he says. Even if you have given it is as a reward, that's not the charge. Charge is 51D.
My lords, defect in charge, I have just pointed out the relevant section, my lords, 215 regarding error or effect of errors.
Vital difference between reward and this thing. The entire story changes. The complex changes. That is what his attempt is to,
Well, it's in my respective submission, my lords, demand acceptance and recovery has been proven well, my lords, from all aspects. And even the witnesses' oral testimony seems to be very specific. And
that's right, but
and they have withstood the rigors of cross-examination also.
Successfully, the doubt is being created. You have to prove the case beyond all reasonable doubt.
Right.
There is some doubt created. There is some doubt created. How to get over that doubt? On the provisions of law, charge, FIR, evidence, and the motive behind it, and occasion for him to go and pay. And that fortifies his stand, that which you just now you read it. If you are so gentleman and giving the money after the work is done, therefore he put forth his defense saying that yes, it was in fact loan. He is a gentleman, no doubt he is a gentleman. That gentleman, after getting money, he returned the loan. He was so gentleman in 89, he goes to the police.
Well, that factum of loan is not.
And then maybe he was trying to fix him.
Well, the factum of loan is not being corroborated, my lord. Doesn't has been established. If your lordship kindly once again come to the factum of loan aspect, my lord.
Yes.
Yes, my lord. DW1 has been dragged in to prove regarding the factum of loan.
Yes.
So, your lordship may kindly come to DW1 page 49.
And 313 is very clear stand.
Yes, sir.
Very clear stand taken. Generally, yes, no, kar dibe. He is taking very categorical stand. Dhara magiva, dhara magiwata only mane ଦେଖିଥିଲେ ଆଚ୍ଛା ଇଏ ଧାର ମାଗିବାଟା ଅନ୍ୟମାନେ ଦେଖିଥିଲେ
So that's not about the law, my lord. This explanation doesn't stand. This explanation fails to stand because they have roped in DW1 to prove the factum of loan. Lordship may kindly come to the cross-examination, my lords. Page 49. 49, my lords, of the paper book.
Okay. Yes.
I don't. Lordship got it, my lords?
Yes, sir.
I do not know when Nandaram Banchor had retired from government service as sweeper. I cannot say the strength of sweeper serving at VSS Medical College Hospital, Burla. I did not keep an amount of the loan amounting to rupees 500. Account of the loan amounting to rupees 500, which I had advanced to the accused. Nandalam Banchor had his residence close to ours. At about 5 p.m., we had
This is important. At about 5 p.m., we had
been to his residence for the balance loan.
Yes.
Now, this is important. I cannot give its date. Then thereafter, what he says. When the accused was trapped, he reported me about the loan taken from Nandaram Banchor. I could recollect the month when he had been to Nandaram Banchor. I was not present on the date when the accused was entrapped. He reported me about the loan taken from Nandaram Banchor 25 to 30 days after we had been to the house of Nandaram Banchor. Well, this has been clearly analyzed by the court below at judgment page 15, your lordship may kindly come. How it has been analyzed.
And he says that 1500 rupees was asked. 500 I gave 500 and another.
My lord, the dates are important. Where he says 25 to 30 days before, that is important. Page 15, your lordship may kindly have page 15.
Yes.
That was the sentence beginning with the defense witness is not to be believed. 1, 2, 3, 4, 5, 6. Seventh line from top maths.
Yes.
The defense witness is not to be believed because he could not give the exact date when he took the accused to the father of the complainant for the loan of rupees 1000. He is a person having deposed in another police case. My lords, he is a stock witness, my lords. This witness is a stock witness. He could not recollect the date when he had been to Nandaram Banchor, the father of complainant, to procure a loan for the accused. His statement that the accused had reported acceptance of the loan from Nandaram Banchor, my lord, this is important, 25 to 30 days after he and this witness visited the house of Nandaram Banchor. The incident took place on 28/6/88. He has stated in his chief examination that during the 3rd week of June 1988, the accused requested him for the loan. So if this period, that is 3rd week of June 1988, is taken for consideration, when both the accused and this witness has gone to the house of Nandaram Banchor for the loan and the trap was laid on 28/6/88. His further statement that 25 to 30 days after they had gone to the house of Nandaram Banchor, that is during the 3rd week of June 1988, it becomes gravely doubtful. 1 month after 3rd week of June 1988 would have been 28th or 30th of July 1988, but the trap was laid on 28/6/88, the day of payment of bribe by the complainant to the accused. Now, this witness cannot be relied upon. This is my respectful submission. So also being a stock witness.
Where does it come that is a stock witness?
My lord, deposition of DW1, my lord, he has deposed in another police case. Page 49, your lordship may kindly.
Last but one line, yes.
Last but one line.
I had deposed in another police case.
That's page 49, last but one line.
In my life,
I had deposed in another police
case. It's not effect. In my life, entire life, one case. Stock witness means stock witness means not that one case somebody is. Yes. Yes.
So, my lords, therefore, my lords, DW1 witness cannot be believed upon. He has given prevaricated statement. Therefore, the factum of loan that has been said, that has been taken is not admissible. It's not plausible at all. Because DW1 has been roped into proof that a loan was taken, but his witness cannot be believed.
Yes. Then your case is demand is proved and acceptance. is
Acceptance
proved. So
requires
therefore, nothing else need to be considered. These two things is enough for the maintaining the conviction.
There is no perversity in the judgment.
Perversity. That's what. Okay.
But only in reply one thing. A learned friend speaks about charge and refers to 250. 215 here is specifies unless. There is a word unless in the middle of it. It says, now what is the purpose of charge? That I am to be aware of the accusations.
That's the idea of it.
So if that is the purpose of the charge, my lords, what 215 says? Unless the accused was in fact misled by such error or omission, and it had.
That's the idea of
Exactly.
because of the wrong charge, he's misled. He could have led other evidence also.
Yes,
Who knows? Who knows? What kind of evidence he would have left depending upon the charge being thrust upon him. The charge is different than that's what his case is. You please write down. Heard Mr. Devasis Panda, the counsel for the petitioner, and Mr. Rijvi, any counsel for vigilance, judgment reserve, and parties are directed to file short written submission
With citation.
with citation within a week.
Well, within a week, ma'am.
Within a week.
Yes.
Judgment reserve. Judgment reserve. Yes.
Other item, hearing item 126.
Let it be there.
This week I will be.
It's all right. You inform. Not necessary. One matter, two matter, whole day it takes.
Yes.
Because particularly this vigilance matter takes its time.
It's
not-
time taking minutes.
And hearing is easy, and we have to write it also.
Yes, ma'am.
So it takes time.
And his judgment is also going to be very voluminous.
Depending upon you, how easy you can make. It can't be voluminous. It is very, you have to, in a revision, I need not keep on writing so many things.
No, this is
But it's very. Huh?
Appeal, my
It is
lord.
an appeal. It
Yes,
is an appeal.
Appeal.
It's appeal, then it has to be. We have to deal everything.
Yes.
Please
Definitely.
give citation. Please.
I'm very precise, my lord, within 10 pages.
Yes. Yes. Weekly, anybody is ready? Let it be.
Increase 91 item onwards.
Anybody is there?
No.
I told you that old matters.
My lords.
You just spend little time.
Yes, my lords.
Just see
Age.
Age and all.
Age, yes.
Wherever it is beyond
I will so much send the
75,
my lord.
same order.
Yes,
You give the
numbers.
give the
Nice.
SP's area.
Yes, ma'am.
SP will give a direction to verify and page it.
Yes.
No, 95, 97, 150.
हाँ, सेटा ही था।
वो फाइल दिखाई दे जो hearing route अच्छी just for example let us see 90 we have done
90 just now completed, my lords. Hearing completed.
90 completed
91 perhaps has been adjourned.
91
Huh? Not adjourned.
not adjourned.
Means
Let us see 91 for example I am just saying.
I am having nothing of 91.
Oh, it's all right. I'll
My lords.
I'll tell you. This appeal, when appeal was filed in the year 1994, okay?
Yes.
That time he was 39 years. 94, 39 means how much?
69. 69.
69, 70. No? 69. So this is how you have to find out and get the information.
Any appellant above the age of 70 or my lords? What is the bracket?
70 you
Above 70.
70.
That is the bracket.
Near about 70. 70, then we will take it up. In many cases, it is beyond 90.
Well, in any case, if it is above 70, you would be sending the instructions.
Get a
Yes.
status report so
Yes.
that we will get an idea.
So that up to 2000, we can do the same exercise.
Same exercise. Just
Yes.
spend little.
Yes.
Okay, thank you. Revision रे आपण देखील revision रे ते पूर्ण revision नाही.
70 cases manner, and where you know, directly in the sentence undergone manner. In that cases manner, I am little confused manner while searching the distance manner. Minimum sentence 7 years.
7 years in the after amendment. Before amendment, there was a provision that by giving sufficient reason, the sentence can also be reduced. Proviso in 176, 176 itself, there is a proviso saying that by sufficient reason, the court can.
That is where, for that in the Apex Code manner, categorically stated that the reason should be assigned manner while reducing.
The reason I will not like resign. Obviously,
Without reason, in all
there
orders.
is the delay itself is a reason.
Reason. Yes.
Delay of 20 years, 30 years,
For that.
because we are following the criminal jurisprudence is for reformative this thing.
Yes.
At this stage, we can't send someone to jail.
Other offenses you can reduce. So for 376, reason is.
Reason has to be given. That proviso says there with sufficient reason. That reason I will give.
That is